guess we were concerned about petitions becoming a vehicle for private parties, two private parties in dispute could, under a member of the House's petition, bring it in. It could be slanderous, it could be, we'd have no control over what content would be in that petition. And it could become very problematic. Under the guise of legislative immunity, you could have people slandering one another. We didn't want that to happen. No one wanted that to happen. We talked about the Sherburne v. Merrill case, Merrill v. Sherburne, and how that case back in 1818 basically states that if something has been adjudicated by the judicial branch, it can't be appealed, overturned, or otherwise dealt with by the legislative branch. And we toyed with the idea as well, maybe if that's true, some of these petitions could be thrown out, but to do that, we'd have to have a screening process. Now, who would screen it? The speaker? No, that would be too political, we thought, whoever was in charge. Then we said, well, the Rules Committee, well, the Rules Committee really deals with process, not with substantive issues. That didn't make much sense. So basically, we did more research and looked at how have petitions been used, both historically in the United States, I mean, in the 50 states, and more specifically in New Hampshire. And pretty much they've always been used as non-binding communications. Some in the past were used more as almost glorified letters. If a town was complaining about a piece of legislation, would come as a petition and then go to the chairs, but then not acted on, just communication to the legislature. Almost always they've been brought into the clerk's office and read. That's also the pattern across the United States. We didn't go to the background of all those across the United States and the other states because their constitutions may differ. But what we decided to do as a subcommittee, and what we're recommending to the Rules Committee today, is, and I'll go through these three rule changes here, with the added caveats that we would say that what we passed here today should be interim for these 2 years, because this kind of was sprung upon us. We didn't have enough time really to deal with this completely, although we think we kind of vetted out the major issues. So we would like to request of the Rules Committee and put on the record that this is an interim measure, and that this is something that is non-precedential in the sense that this won't be used as precedent, and in the future, other legislatures in the future, other general courts can look at this and change it without using this as necessarily precedent. The changes that we're doing, we try to minimize the amount of changes we made in the rules. And the first one is amend rule number 4, which basically we all agreed in the committee that petitions involving elections and qualification of members should be treated differently, because those do in fact go to committees, and those do in fact need to go through the whole process. So we call that out in this rule change, adding at the end. First off, we took petitions out above, just for clarification, to make it consistent, and down below saying the speaker should refer a petition to a committee only if the petition involves the election or qualifications of a member to serve in the House. So that's carving out that exception. Second one was to amend Rule 18 to make it clear that petitions are presented and the subject matter is read in summary. So in the second line is a change from person to member, just to be clear that members actually bring in petitions. And then in the second sentence, the speaker shall state the substance of the petition. It says in concise form above, and it says substance of the petition below. It's not the intention to have this whole thing read on the floor of the House, but it is to the speaker, or the speaker ordering the clerk to do so can read a summary of the petition. And then this is kind of the crux of what we're recommending, I guess. This next sentence is the petition shall be entered in the journal by title only, and the full petition shall be placed on file with the clerk. That way, no one's screening these. Whatever the OLS will draft them, whatever the content of them is going to be the content of them, but they're going to be basically identified by titles, briefly explain what that involves, much like we do with a bill saying what it's in reference to, and that's going to be placed on permanent file with the clerk and eventually archived, down the road. The last thing we recommended is amending Rule 64, which is deadlines, and having petitions, since they are drafted by OLS, to be treated the same as bills. That the last day to sign off on House LSRs including for requests for petitions other than petitions involving elections or qualifications of a member to serve in the House, shall be whatever date. And the reason we carve out petitions again is because you could have special elections in the middle of a session that could be past filing deadlines, and in that case you would need to have that petition accepted. So that's basically what we recommend. The last thing we wanted to recommend to the Rules Committee out of our subcommittee, which was a 3-0 vote today, is that the 5 pending petitions that have been drafted by OLS, which the clerk has, which came out recently, that those be allowed to come in, obviously, when we pass these rules, that they come in under these rules for this session. That's the recommendations of the subcommittee. I know there may be others that I want to testify today. And certainly other members of the subcommittee are welcome to add anything I forgot.
Is there anybody that wishes to testify on the petitions?
I have. Thank you, Madam Chair. It's my recollection that during the subcommittee meeting that I was at today, that the petitions were to be treated as communications, and that communications are typically read by the clerk. And so, rather than referring to it as being read by the speaker, I think we discussed in committee that it would be read by the clerk. Or you discussed in committee, I am sure.
Yeah, we did say that, I guess. I guess it was thought, because this appears elsewhere in the rules, where it asks the speaker shall state, the speaker can ask the clerk to read on behalf of the speaker, isn't that?
Well,
is that
how
true?
are the other?
Is that true? Clerk?
The speaker can always ask.
Yeah.
Clerk.
Yeah. So that's why we didn't change it for that reason. I think we discussed changing it, but we just figured the speaker would order the clerk to read the petition. We did say in familiar language that yeah, the clerk will read it. Yes, we did.
And typically, what happens, like for resolutions or something that the clerk reads, the speaker would say the House will attend to a communication, or the House will attend to a resolution, and the clerk reads.
But in the rules governing those communications, it says the speaker shall read and then you delegate.
In many cases, I think that's true.
I don't know if we have.
I was just going to say, in House rules, it does not specify at all that the speaker delegates.
Okay.
Or that even that the speaker would read communications or resolutions. I mean, to my knowledge, unless the clerk tells me something different, that's not addressed in our House rules at all. So we would approach it in the same way as we do all other communications.
Okay.
Is there anybody else that wishes to speak?
Thank you, Mr. Just briefly, I just want to encourage you to go this direction just for one reason, and that is all the energy that we watch and see in the national constitution, that we see in our constitution, is clearly around getting as much as possible in terms of representation, getting government close as possible to the people. And the ability to redress, actually to get somebody to respond, not just put on the record that somebody complained, but actually to get a response from us, from we the people, legislative representatives, just to me quite a crucial piece of this. Obviously juries were a piece of that, and it goes on, but this is a piece, and we've sort of lost it, oddly, since the 60s, if not earlier. And that's what I just want to encourage you. Thank you very much.
Is there anyone else that would like to speak to this? Okay. Are there any members that have any questions for the subcommittee? Any comments or discussion? Representative Jasper.
I just want to make sure I understand clearly what it is we're doing, because as I read this, it is merely going to be read and placed on file. The House is, the intent is not for the House to take any action relative to these petitions. That's correct. Okay.
With the exception of...
yes, with the exception of election challenges.
Election-related petitions. Any other questions? And would you like to make a motion? Huh? Representative.
Thank you, Madam Speaker. I'd just like to comment on Representative Jasper's comment, and that is that does not preclude any member from reading the petition, going to the clerk's office, reading the petition in full, and taking action if they so desire.
Right.
under existing rules and conditions.
Mhm.
Thank you. And I would make a motion if I might.
I would, oh, you were on that committee too.
Oh,
Okay,
yes.
Representative Foster.
Thank you. I would move,
Representative Baldessari.
Thank you, Speaker. What do you mean by any representative, any legislator taking an action going up there to read? I mean, what is left on this petition that could happen? I mean, this is just gonna be something that's gonna be spoken at the, when we're in session, and then it goes away and goes up to the clerk's office, gets files in a drawer? Is that what we're saying that's gonna happen? I mean,
Well, it will be filed on record, so anybody can, anyone, whether they're a member or not,
Any
it
member of the
is
public.
public record. So they could go
Right.
up and read it on, read the file, and afterwards, after a certain period of time, it goes over to archives. So it would be available as a matter of public record.
so the final decision basically is the petitioner by Constitution has no say, nothing, anything that he's already tried and exhausted all means within our court system. There's no other ways to go. I mean, that was our main intent on this here. That's why we went this route.
Representative Campbell.
Well, it was felt by the subcommittee that based on how petitions have been treated in the past, historically, that's how it's been handled. The reason for not going further is it became very problematic as to how, if you do refer it to a committee, what does the committee do with it? Does the committee take further action on it? Do they have public hearings? If we were opening up can of worms after can of worms after can of worms if we started taking further actions for these. We decided to treat them as they've been treated historically, to put them on file, understanding that way we're not screening the contents, that the ones that are coming in, because we felt if we had a screening process, we'd probably have to screen out all the ones that were previously adjudicated, because we didn't have the ability to hear them as a legislature, since the judicial branch already did it. But we get rid of all that. We in fact do take all of them in, but we don't sanction them. We just accept them as a communication, more than a communication, because it is a petition in a certain form drafted by OLS. Then it goes to the clerk's office for permanence and is open to members of the public to see.
Representative Baldessari, would you like to take a seat?
Yes, I'm actually going to be paying to these.
Sorry.
So in other words, then, consistently, did your rules come up with some type of, like for instance, for me to go back to my constituent, who I've sat in the courtroom many times and I've read hundreds and hundreds of documents on the misuse of the court system, on rubber stamping, which we've seen going on. So is there something that I have to tell him, you're done, that's it, you're over with, there's nothing in our Constitution, in our state of New Hampshire, since there's no way of the judiciary reviewing the judiciary, because we've already failed that route. So I have to go back and tell him that this is it, end of discussion, the rules did not come up with any other suggestions, solutions to correct this problem.
I would state that from our investigation of this, the petition process is not a form of relief for that. You do have the option, if it's appropriate, every year actually, to file legislation. And the petitions, I don't think in this state where we have easy access to representatives and to introduction of bills, it wasn't the intent of, the historical record doesn't bear out, it wasn't the intent of the subcommittee to allow this to become a different vehicle to bring legislation in.
Thank you.
I don't really want to sit down again, but I actually read a bunch of the responses. The federal court has made decisions and corrected decisions and ordered payments and all sorts of things. I'm surprised that you guys didn't run into that, but we have done that. And redress and petitions and grievances are three different things. A petition for redress is asking for redress. A redress of what? A grievance. So they've made their grievance by way of a petition. It asked you for redress, and we're going to file it. I ask you not to do that. Please don't do that. We redress it, hear it, make a decision, take it to the general court, and what would a bill look like? Tell me what the next step would be. Where does the person get redress? Redress is us addressing something to correct a bad situation caused by government, which is the correction we're looking for. I don't understand. I don't understand at all if you're not going to do anything at all unless we don't have redress.
Representative Winslow.
I think Representative Itse was in the committee when we discussed this. I wish he hadn't stepped out. We should talk to him. This does not preclude after this is read into the record, a representative or a committee chair or a representative, members of the committee from taking this issue on, doesn't preclude a representative from getting up and speaking to the body on the issue. This is my understanding. So it doesn't close off the issue, but it does give you a vehicle to speak, to get it before the body, if the body wishes to take it.
Could somebody explain to me how that might work then? Is that clear to someone, how that would work?
It's read to the.
The petition's in the House.
It's
It's been filed somewhere.
It's on, but it's not on file. It is read to the body.
Summary.
Or a summary. The summary will, if at that point if there are members of the House sitting there from the various committees, the chairs of the committees, if they see that there is if they feel that there is an issue that needs to be addressed by the body that could be addressed legislatively, they would do that.
I just want to correct one thing. I don't believe the petition would be in order to come before the House under rules. You'd have to amend the rules to allow it to come before the body. The intention of this is to have it be filed. The intention of this is not to have further action on the floor of the House. That is the intention.
And then I
Okay,
did not
okay,
say
clarify
action.
that. I want to make
Yeah,
it,
that's, I did not say action. The action would be by the committee chairs or by the individual members to take the issue forward.
Which would be at the next session or something like
Yeah.
that.
Or a committee chair, if there was a petition that was brought to attention of the committee chair could say, we're going to have a public hearing, we're going to have a hearing on this subject. This is something in our purview, and we'd like to have a hearing on this subject. Just informational. It wouldn't be binding, wouldn't be a bill, wouldn't be legislative, but that could be done. The fact is, because these aren't being screened, and just because somebody asks for redress, I mean, what they may be asking for may be unconstitutional. It may some of them that I saw talked about requiring Senate action. I mean, this is only a House petition; has nothing to do with the Senate. Some of them are again trying to override or being appealed to judicial, and the Supreme Court rules that say you can't do that. So without getting into all that, we basically take the subject matter. Petitions are one of the first orders of business, I believe, aren't they? It's the second, right? So it's read by summary and it's put on file. Any member wants to see it. I mean, it becomes a public glorified communication, if you will. But it's certainly a much. But it does get its day in the legislative journal.
But the question comes back to how does one get redress? And so I'm asking, Andy is Representative Rizzuto, it's correct, we're capable of giving redress. That's it, correcting something. And I would, as a member, then, having seen that thing, or possibly have encouraged the petition to be brought in the first place, I would then march down to Committee X, and say, can we have a hearing, or would I have an ad hoc hearing of my own? How would one move to the next level? Do I have to wait a year then actually to get? See, the redress of grievance idea is to get it into a hearing now and have it heard. Not half the bills we hear might be unconstitutional. We still hear the rules. They come into committee. I see them all the time. And we do. When we bring our bills, we do our very best. They're not necessarily constitutional, but we hear them. So the question is, why not, instead of going into a file system forward, a circular file probably in this case would be affected.
Again, only speaking for the subcommittee, I think it was important that it was not the intention to make the petition process a second form of bill writing. That bills are, that we have a system to set up to pass legislation, and that's the introduction of bills, and that petitions are a way for people to express their grievances. They can ask for redress, but really the proper way to do that is through the legislative process. A prayer for redress does not mean that the prayer has to be answered necessarily.
I think I'm getting at what it is, and I'm asking whether or not what it is I bring a bill in then to hear some such grievances. Would that be the case? Would that be what we're hearing now?
I mean, I think that's the option, right?
Would you like to make any further comments to for the
You
community.
know, I would like to propose that, though, so we actually get, before this is over today, there's actually a way of actually moving the address and not just filing a petition. And that would be, my proposal would be to actually just say, let's, all right, you can write it in there if you like, or find a way to write it in there that says members of the House may bring petitions for redress for hearings before the various committees.
Thank you. Are there any other questions for the representative? Thank you very much. Representative Jasper, did you have a comment?
I had a comment, perhaps, question. I think I clearly understand the intent, and I don't disagree with it. I believe that any member of the House could then, if there was timeliness, come to the committee and ask for a late introduction of a bill based on petition. I guess my question is, since nothing is going to happen except it's going to be read into the record and placed on file, which my understanding for the last who knows how many years, the petitions have come in and essentially gone in a circular file. Nobody's known about them. This makes everyone aware of them, which is a vast improvement over what's been done. Is it necessary to have a member of the public then find a representative who is willing to bring the petition in? Couldn't the petition be, what is the reason, I guess should be my question, what is the reason that we're requiring it to be brought in by a member versus just a person filing it with the House, which
I believe that's the way it's set up now.
May I address that?
I'm sorry, no. Representative Campbell.
David Fryman's here, who is the counsel to us on that, but I believe that's the way it's set up now. Isn't it, David Fryman?
Yeah.
If your question is whether or not an individual has the right to file legislation who's not a member, no. Right now, in the state of New Hampshire, you have to be a member of the body in order to file legislation.
No, the question was petitions. Petitions have to come in by members.
Yes, petitions also have to be filed by members.
That's what that's the information we had, so that's what we're basing it on. I will say one other thing, because this is the last day for this session that we can get something in from the Rules Committee to get on the floor before the deadline, that it doesn't have to be amended by 2/3. We told Representative Itse at our subcommittee and tell others, if you have something that you want to be considered for the next biennium, a specific way to handle petitions, we certainly can look at that. But at this time, this is what the subcommittee is recommending for Rules Committee.
Representative Foster.
Yes, thank you, Madam Speaker. And I would just add that I think the discussion that's ensuing here speaks to the fact that we should not do something quickly which could have unintended consequences and might not reach anyone's intended goal. So I truly believe that the solution set down in these 3 amendments here is, at this time, by far the most judicious and wise solution.
Is there a motion on the floor?
I was just going to ask whether I recognized
For a motion?
Oh, okay. No, that's what I thought I was recognizing for, which is why I was not clear. So would you like to make a motion?
I'll move that we adopt the subcommittee's recommendations as presented here in 3 points on this page.
Is there a second?
Second.
Representative Renzullo seconds the motion that we adopt the recommended changes to the House rules with regard to the petitions that we have before us. Is there any further discussion? Are you ready for a vote? All those in favor say aye.
Aye.
All those opposed, nay. The ayes have it, and the recommendations are adopted.
We got, I would say, 70% of what was desired, 100% more than we had, and next session is another session. Now it's up for us to approve the utility of what we have.
Okay, but my understanding of what just happened in there was now the difference is the petition is actually somewhere where somebody can read it, but regardless, the petitioner must still go through their representative, which is exactly what they do now.
That has always been the case.
Right, that's what I'm saying.
No, but I mean, the constitutional process has always been submission by a legislator.
Right, but the
What-
redress still doesn't, the
What we
petition
have
still
now-
doesn't play a role.
What we have, nothing prevents a committee chair from taking the topic of a petition and hearing the subject matter. We have gotten our nose under the tent. Now it's up, I have a friendly committee chair who wants to hear petitions regarding the marital masters. She wants to have an ad hoc committee, and I have told her I will handle it. Now it's up to us to prove the utility of the process.
But why couldn't you just, why did we have to go through all that? Why don't you just submit the legislation?
Because you would end up, well, first of all, every one of these petitions is not just a single subject matter. It involves, in many cases, bill of address. It involves reparation for harm done, and many of them involve change of venue for future action. That would require 3 bills, at least, and so each petitioner would have to come up to be heard 3 times. This makes it only one action on the part of the petitioner. It also means that in regard to things like marital masters breaking the law, that the committee can hear all 3 petitions at the same time, and so they get they perceive the pattern of abuse, rather than it being entered, a bill of address being entered on behalf of a particular citizen. So it's moving toward presenting the problem, presenting the problem rather than presenting the solution. Allow the legislature to craft the appropriate solution, especially when you're coming into issues that are very tender.